will address anything.
I just wanted to speak
Yes.
up for myself, sir, because I'm not a criminal, sir, and I really, really do need to go to work, sir. And the CPS worker is going to be providing those information as well. I, I'm sorry, sir.
That is all, Your Honor.
Let's call the case. People versus Jaleesa McDowell.
On behalf of the people, Your Honor. Asli Bashir on behalf of Jaleesa McDowell.
Oh, Jaleesa McDowell.
And Your Honor, we would like to address bond in this matter and request the briefest possible adjournment.
Okay. Go ahead. I'll let you address bond before I give you the date, I guess.
Thank you. Before I kind of address the substantive bond in this matter, I do want to address kind of clerical error in another case. The court may see that for case, there's a case out of 1482, 25203, or, oh, sorry. Okay, actually, you know what? I'll save that for the end if it comes up. Just because it looks like she's being held on another matter for a higher bond than she actually has, at least in the system that I.
Out of my court?
Oh, sorry, 1482.
So what would you want me to do with that?
Well, in case that was part of your consideration for.
Oh, I see.
Apologies.
You don't want me to change it.
No, I do. Oh, so as far as this matters, yeah.
You can go to Judge Barr, but go ahead.
So as far as this court is concerned, Ms. McDowell is being held on a $50,000 bond. This is the result of an emergency bond motion and the court's order in response to that motion, that hearing on the June 16th. Circumstances have changed since that hearing. My understanding is at that time, the complaining witness was residing very close to where Ms. McDowell resides.
Have the circumstances changed to the extent that the allegation of a knife to the body or hand of a 15-year-old has changed?
Yes.
Well, the charged alleged conduct in the police report, as far as that report, which we have not had any substantive hearings on the merits on that matter, but the report hasn't changed to my knowledge. But we have stood mute on that matter.
Yeah, screenshots.
Yeah, and we do. We are gathering discovery on the matter, and I would say in terms of the kind of concerns related to bond about Ms. McDowell being close to the complaining witness, I do believe that the complaining witness, I understand, is residing in Detroit with her grandmother. She no longer resides next door to Ms. McDowell. Ms. McDowell also she's been in custody for 15 days on this matter. She is willing to go on GPS tether. She has, support in the court. She has a coworker and friend who is here today. Her sister was planning to be here today, but was not able to. I do think that additionally, the hardship of her being in custody is something I request the court take into account. She's concerned about the security of her residence. She's been informed that there has been potential vandalism and potential people breaking into her home while she's been out. No one else is officially residing there. Ms. McDowell has there's no allegations of Ms. McDowell trying to contact the complaining witness. There's no allegations that she's been making jail calls. She has no intention of contacting the complaining witness in this case, and she understands the seriousness of that. And so I do believe that the being held in custody on a $50,000 bond is excessive in this matter. We can address.
You're saying the bond I set was excessive?
Well, at present, given the current circumstances, which have changed, the information you had before you then is not the same as the information as it is now. Of course, I would not question the court's judgment. But specifically, because of the potential hardship to her and the concerns about her home, the concerns about the fact that she is no longer anywhere near, she won't be anywhere near the complaining witness. And, she has already been in custody for 15 days. The final matter is, she has, she works as a supervisor at her workplace. She's been there for 5.5 years. She is very concerned about, her job. And so I would request, that she be able to be released to work. I understand that one of the release conditions includes a GPS tether. She's happy to go on a GPS tether and follow any conditions this court thinks are appropriate for her to be released. But if the court would consider, you know, her.
Where are the other two children?
My kids were left at
Yeah.
home attended for 2.5 weeks, and I literally moved my kids to Detroit to my mom. They are safe now, and I did sign my rights over, sir. But my children were left home attended for 2.5 weeks. I sent cash up money to them.
Well, this is
it was a
Mrs.
safety
McDowell.
concern.
I don't think we want to address anything with the children right now, other than the fact that they're residing with a
I
grandmother.
got the move. I just want you to know
yes.
that, sir.
And Ms. McDowell, all 3 children are living with a grandmother.
I'm working from my jail cell for 3.5 hours a week because I had to still provide for my children because I knew that they were home left attended. I have that on recording on the jail cell as well. With the CPS lady, her name is Tiffany Avery, sir.
And to be clear, this is not a conversation involving the children. It was just.
And I've never been accused of anything violent. The other accused, the malicious property destruction, I have a $10 bond, sir, and that is taken care of. And it was just you prosecuted her rapist, and that was the
Ms.
dad.
McDowell, I think if you can just hold off on a second, I think we'll address anything.
I just wanted to speak
Yes.
up for myself, sir, because I'm not a criminal, sir, and I really, really do need to go to work, sir. I've exhausted my funds and I've been taking care of my children for 2.5 weeks. I didn't make contact, but I do know that they were home by themselves. And it just was discussed. And the CPS worker is going to be providing those information as well. I'm sorry, sir.
That is all, Your Honor.
Your Honor, the court's familiar with this case. I'm not going to re-exhaust the motion that we filed. The only thing that I see that's changed since the last hearing is that the children have been placed with that grandmother in Detroit. The facts of this case still stand that she is being stabbing her daughter with a butter knife so severely that her daughter needed stitches in her hand. I mean, I have severe concerns, and not only that, she threatened to kill her daughter, and her daughter was so afraid to contact police, she had to text a friend to call police because she was so afraid. I mean, I have great concerns, even if she is released, for her children's safety. And this is a very significant case, and I believe in our bond form, our original request was $100,000, so $50,000 as set by the court is appropriate in this case and should remain as set.
Your Honor, if I may address that, there is no history of violent conduct between Ms. McDowell and the complaining witness in this case. The basis of the statements that were just made by the people are entirely the police report in this case.
And
Again,
her stitches.
Well, the basis of the allegation that Ms. McDowell is the cause of the injury is based on the police report. That has not been addressed on the merits. And again, there's no history of legal issues or reports of violence between Ms. McDowell and her children. I would say I don't believe. I would like the court to consider the gravity of holding her in custody on the basis of just the police report at this stage of the case. No allegations that she has violated her.
Telling me it's wrong that the child was at the hospital getting stitches, counsel, and that's what I should consider?
I want the court to consider the fact that that Ms. McDowell has stood mute. The court has entered a not guilty.
I understand all of that, but you're asking me to consider her hardship and saying that there are certain things that may be objective in that police report that I shouldn't consider that.
I would like the court to consider the fact that Ms. McDowell is no longer going to be anywhere near that child. So if there is a concern about the possibility that that injury may have been caused by Ms. McDowell, which we deny, that would be addressed by that fact. In addition to the fact that there would be a GPS tether as part of her bond conditions.
And I did also make the record clear. She does have a previous conviction for domestic violence from 2018. She also has a previous conviction for larceny from 2020, and she also has the pending case of the MDOP with another domestic relationship. So I mean, I do have concerns. She does have an assault history, and given this case, I have concerns that it's escalating from what her previous history is.
Your Honor, none of these cases involve Ms. McDowell's children.
Yeah, but you said she didn't have a violent history. She got a DV conviction. Motion for bond reduction is denied. Bond will be continued.
For the judge. Court shall feast on behalf of Mr. Barrage Scott, who is the person on the podium. Mr. Scott, please state your name for the record.
Well, Dante Scott, sir.
How you doing?
All right, just glad to see my family in here. That's all.
Thank you, Judge.
Been here every time for you. All right.
Thank you, Judge. I believe this is a competency review. My understanding is that we do have a report. Scott is competent, Your Honor.
Yes.
We stipulate that, Your Honor.
And the people?
Also stipulate.
All right. The court, having reviewed the report, would find that the defendant is competent to stand trial. defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is found competent.
Judge, I'd be asking this matter be set for a PCC, and Mr. Scott would like me to address bond as possible.
All right. Probable cause conference will be set for July 10th, 2025, 9 a.m.
Thank you, Judge. I've had a chance to talk to Mr. Scott about the situation, and I've relayed to him how serious of a charge he is facing. Mr. Scott is still asking that I seek a personal bond from on this case, Your Honor. Although the court does see that Mr. Scott is competent, Mr. Scott does indicate that he suffers from a variety of mental health conditions. He indicates that he would love to get this situation resolved. He would love to see the prosecutor's office potentially offer him a mental health court resolution. He says that he's not going to run from this situation. He has family support. He indicates that his mental state is in a much better place now than it was at the time of this alleged event. He indicates that he has a grandmother who is involved in his life and who will help make sure he attends any and all court dates. He indicates he will go to any outpatient or inpatient treatment that the court does require. He also has no objection to being on a tether. He indicates he's willing to just address everything that's going on in his life, Your Honor, that he will not be a problem for Your Honor should the court release him. He's asking that Your Honor consider a reduction in bond or a potential personal bond. But again, I have relayed to him how serious of a charge he's facing. But I believe that's what you want me to argue. Anything else? Mr. Scott says that he's on his medication now, and he's obviously much better when he's on his medication than he is when he's off his medication, and he will stay on his medication should the court allow him an opportunity to be released. And that the nurses in the jail have upped his medication in certain areas and have him on a shot and a pill form.
Yes.
And so his mental mind frame is in a better place, and he will do anything and everything the court asks if he's asking for a potential release.
Response.
I would ask that bond remain as currently set. I appreciate Mr. Feaster's advocacy on behalf of his client. I'm struck by the language in the competency report. Mr. Scott affected a volitionally uncooperative response out during the evaluation process and attempted to feign legal knowledge, memory deficits, and symptoms of severe. Candidly, if you're uncooperative in the underlying competency evaluation, given his criminal history and the facts of this case, I believe that he is a danger to the community and has severe handles.
Nothing further, Judge.
All right. I am going to deny the defendant's request for a bond reduction in this case. I think the bond is set appropriately. I would further indicate that Mr. Scott's been appearing before this court for quite some time on various matters. And typically I can let Mr. Scott out of custody, may come back in, but usually for minor things. Mr. Scott was in custody. I took a chance, released him. He did not make it a week before this came up. Mr. Scott was. So I'm not going to take that chance again, especially since it's
You understand what he's saying to
a
you?
violent case.
Hold on, do you understand what he said to you?
So
He said that he let you out. This happened a
I
week
know,
later.
but he keeps saying the same thing.
Okay.
Saying the same thing that he's saying.
Okay.
It's not.
I believe Mr. Scott wants to address you directly, Your Honor, if you'll.
go ahead, Mr. Scott.
Listen, Mr. Simpson, I know you kind of keep, going back in the past, right? But this is my life. You know what I'm saying? My grandma's here, my family's here. People are making me look bad. Even a competency hearing, they're making me look bad. I answered everything what I was supposed to answer the right way, and the prosecutor is saying I was I wasn't cooperating the correct way, and I was. It seems like I had to take 2 competency tests, and the first one he just said what he wanted to say. I'm asking if you release me today, because I gotta go see Slay today. They said if I do get released, they're gonna follow the same recommendations you will follow if they put me on tether, if they put me in, you never put me in no classes. You never ever put me in no classes or try to do anything like that. I want my days to be filled. If I'm on tether and I have a curfew, I want my days to be filled. I be with my auntie, stuff like that. I go to classes, I go to Don Farms. You know, I need this. I need help. I have a drug problem. I never addressed it like this. But after my sister died last year, she died. She had passed away at 23. I went crazy. I didn't understand half of the things. She had heart failure. You know, it's my grandma. She's 70 years old, something like that. You know, what it happen if you keep me in here and then she just something
Mr.
happens?
Scott,
No, listen.
Mr. Scott, no, you listen. No, you listen.
But
I'm done. I let you out. I gave you a chance. I've given you numerous chances. Saying that anybody's trying to make you look bad, I don't have to go to the past. I let you out. You don't make it 8 days. And now I have you involved in a crime that involves pointing a gun at another person. I'm done.
what do you mean?
Bond.
Listen, can you just let me
Motion for
judge?
bond reduction denied. Bond will continue.
Thank you, Judge.
But
Go
you
ahead.
ain't let me speak
Go
though.
ahead, Mr. Scott.
You ain't even let me speak.
Thank you, Judge.
And just like that, another courtroom battle comes to an end. But there's a lot to unpack from these two very different cases. In the first case involving Jaleesa McDowell, we watched a defendant desperately trying to convince the court that her circumstances had changed. Her attorney pointed to distance from the alleged victim, family support, employment, and a willingness to comply with strict release conditions. But when the allegations involved violence against a child, and the prosecution highlighted both the seriousness of the accusations and her prior record, Judge Simpson ultimately decided that public safety outweighed sympathy. It was a powerful reminder that in bond hearings, emotions can be compelling, but judges are often focused on risk and accountability above all else. Then came the case of Barrage Scott, and the courtroom dynamic shifted completely. This was a man asking for another chance, arguing that he was in a better place mentally, taking his medication, and ready to get help. But Judge Simpson looked beyond the promises and focused on the pattern. From the court's perspective, previous opportunities had already been given, and those opportunities had quickly led back to more serious allegations. It became a clash between hope for rehabilitation and the reality of repeated setbacks. In the end, the judge made it clear that trust, once broken repeatedly, becomes incredibly difficult to rebuild. These two hearings showed that every courtroom decision comes down to one question: should the court believe that things will be different this time? Let me know in the comments what you think about both rulings. Did Judge Simpson make the right calls, or should either defendant have been given another chance? If you enjoyed this breakdown, make sure to like the video, subscribe to the channel, and turn on notifications so you never miss another courtroom showdown. Thanks for watching, and I'll see you in the next case.